The FOP and IACP start with some powerful claims. The legislation exempts any person with a valid photographic identification from state or local firearms law who asserts that they are lawfully carrying a firearm under the laws of their own state of residence. Is that true? Would an out-of-state person with a valid photo ID be exempt from state and federal firearms laws? Well, reading from the law, we find, notwithstanding any provision of law of any state or political subdivision thereof, except as provided in subsection B, and subject only to the requirements of this section, a person who is not prohibited by federal law from possessing, transporting, shipping, or receiving a firearm, who is carrying a valid identification document containing a photograph of the person, and who is carrying a valid license or permit which is issued pursuant to the law of a state and which permits the person to carry a concealed firearm or is entitled to carry a concealed firearm in the state in which the person resides, may possess or carry a concealed handgun other than a machine gun or destructive device that has been shipped or transported in interstate or foreign commerce in any state that has a statute under which residents of the state may apply for a license or permit to carry a concealed firearm, or does not prohibit the carrying of concealed firearms by residents of the state for lawful purposes. So the first claim of the FOP and IACP is patently false. Not only does a person have to be carrying a valid photo ID, but they must also either be carrying a valid carry license or permit from their state of residence. If the person lives in a state that does not require a license to carry, then only a valid photo ID from that state would be required. This legislation goes on to state, this section shall not be construed to supersede or limit the laws of any state that permit private persons or entities to prohibit or restrict the possession of concealed firearms on their property, or prohibit or restrict the possession of firearms on any state or local government property, installation, building, or base. So this law does not exempt people from state and local firearm laws, but only that the state recognize a valid license from another state. The FOP and IACP go on. This is problematic, but the most concerning provision of H.R. 38 is that it prohibits law enforcement officers from making any arrest or detaining the suspect for any violation of state or local law pertaining to the possession, transportation, or carriage of a firearm. This also includes several federal laws such as carriage in school zones and federally managed lands. Again, that statement is factually wrong. In addition to what I've already quoted about state and local laws regarding prohibitions on private and government property, the legislation clearly states a person who carries or possesses a concealed handgun in accordance with subsection A and B may not be arrested or otherwise detained for violations of any law or rule or regulation of a state or any political subdivision thereof related to the possession, transportation, or carry of a firearm unless there is probable cause to believe that the person is doing so in a manner not provided for by this section. Presentation of a facially valid document as specified in subsection A is prima facie evidence that the individual has a license or permit as required by this section. State and local law enforcement are free to detain and arrest people for violations of their firearm laws, just not for the possession, transportation, or carrying, because they must assume that an out-of-state resident who provides a facially valid document that they are legal to carry in their home state must be honored by all states. This is a clear application of the full faith and credit clause. Furthermore, law enforcement officers can still detain or arrest someone for the possession, transportation, or carrying of a firearm. They just need probable cause the person is doing so in violation of the legislation. The FOP's letter goes on. Many states already recognize concealed carry permits from jurisdictions with comparable requirements, such as live training and enhanced background checks. These agreements respect state sovereignty and public safety without federal overreach. This legislation would override these tailored arrangements and strip states of their ability to set and enforce their own standards for concealed carry. Instead of officers being thoroughly trained on their state and local gun safety laws, officers would be expected to interpret any law from all 50 states in real time without reliable means to verify an individual's eligibility to carry concealed weapons, especially those from permitless carry states where no physical permit exists. State sovereignty is important, but it does not supersede the Constitution of the United States, which clearly states that each state must recognize the public acts, records, and proceedings of other states. It is also quite clear that Congress may provide both the manner and effects of those acts, recordings, and proceedings. Furthermore, I find this claim of law enforcement officers having to interpret and apply laws from all 50 states nonsensical. The officer already needs to know what state licenses they need to respect and be able to recognize valid licenses from those states.